All right, Assemblymember Brian, I hope that you can come back to us. I want to press on. Tom, I hope you're back.
Yeah.
Great. And do we have all of our panelists for the next panel?
It looks like it. I'm going to start promoting the remaining people. But we've got our main presenters, which is Sergeant Moida and Jeannie Ho. So I think whenever you want to get rolling, we
And
can.
Assistant Chief Robinson, I mean,
She
Chief
is
Johnson.
she's here. Yes, she's being promoted. But I think the main remarks will be from Sergeant Moida.
I get it. They're both from Highway Patrol. Good to see everyone. Thanks for joining us. We're going to have one more panel and then we'll break for lunch and then we'll come back and hear from some Superior Court judges. If everybody could turn on their cameras, that would be helpful to me. Um, our next panel will discuss perspectives from state agencies and law enforcement. Our panelists are Sergeant Dustin Woida from California Highway Patrol, Assistant Chief Robin Johnson, also from CHP, and Jeannie Ho, Section Chief of the DUI Licensing Unit at the California Department of Healthcare Services, and her staff. Sergeant Woida, can we begin with you, please? Oh, and I know that you guys weren't here at the very beginning, or perhaps not. Please keep your comments to 5 minutes, and then we will. It's really the most important part of the conversation or the presentation is during the Q&A section. So please do keep your presentation to 5 minutes. I appreciate it. That was enough time, Sergeant Moida.
Can everyone see my screen here?
Yes.
Okay, very good. Well, thank you for having me. I'm Sergeant Dustin Boyda. I'm with the impaired driving section of the California Highway Patrol. I currently serve as the California State Coordinator for the Drug Evaluation and Classification Program, which oversees statewide instruction and certification for all standardized field sobriety tests, or SFST, advanced roadside impaired driving enforcement, or ARIDE, and the drug recognition expert training. I wanted to take a minute to go over our training, our enforcement, and our current efforts as it pertains to impaired driving enforcement. Our first level of training, which is our basic level, is our SFST training. Post requires this to be 8 hours taught within any academy in California. However, to receive certification as SFST trained, officers need to complete 24 hours of that training. This requires us to travel the state and instruct an additional 16 hours to any state agency which doesn't provide the full 24 hours within their respective academy. It's important to note that in the CHP Academy, our cadets, by the time they graduate, get more than 50 hours of this SFST training, and they do leave the academy SFST certified. This is a basic level, as I mentioned earlier. This allows the officer to primarily do a roadside evaluation and make a determination as to impairment based primarily on alcohol. The next level of training is going to be our ARIDE training. Within the Highway Patrol, we require this for officers within their first year of being out in the field. This training is going to expose them to recognizing impairment that is caused by alcohol and or drugs. It gives them a heightened level of roadside impairment awareness, which is greater than that of the SFST trained officer. It's important to note, however, that they are still a lay witness as an ARIDE trained officer. That means that they cannot testify as to an opinion. They can only testify to personal knowledge. This training is a 16-hour training over 2 days, and it's a stepping stone to get to our final level of training, which is drug recognition expert. Drug recognition expert officers are trained at an advanced level to perform a 12-step DRE evaluation in a controlled environment away from the roadside. As experts, they can determine which category or categories of drugs are impairing a subject. The training consists of 72 hours of classroom training, followed by approximately 30 hours of field certification. These officers are then trained to be able to give an opinion. They're allowed in court to render an expert opinion on what category that subject may be under the influence of. We have developed our current impaired driving enforcement training goals. As you can see, it is pyramid shaped. Our goal would be that all officers statewide are trained in the standardized field sobriety testing. The secondary goal would be that 50% of officers are trained at that intermediate level or that A-RIDE level, and 10% would be trained as DREs. A brief overview of our DUI laws. I know many of you are familiar with these. It's sometimes easiest to start with 23152B, as that is what we've been talking about for the majority of the panels today, that 0.08 or that per se limit. Now, this says if you are at that 0.08 or higher, you are presumed to be under the influence. As our last panel mentioned, I believe Rick brought this up, that there is an A section which allows an officer to make a determination anywhere in between that 0.05.
1 minute.
Mm-hmm.
Go ahead. 1 minute warning, sorry.
Copy, thank you. The 0.05 to 0.08 range and make a determination there. There's also the F section, which has to do with driving under the influence of drugs, or the G section, which is the combination of drugs. Now, our statewide statistics, it's important to see that there was a decline over the pandemic period from nearly 1,900 statewide DREs to approximately 1,300 in 2022. In 2024, that number stayed the same for statewide. CHP statistics dropped from 764 in 2019, which was a high, down to just over 300 in 2022. It has risen back up to 376. This last slide here that I'll go through quickly, it just contrasts our number of CHP enforcement evals conducted from 5,200 in 2018. It dropped in 2022 down to 1,250, give or take. At the same time, DUID or DUI drug fatalities increased by approximately 61%. We don't believe that this was directly related or directly attributed to the decrease in the number of enforcement DREs. However, we do believe that an increase in DRE trained officers will result in an increase in enforcement evaluations prior to the occurrence of a crash or a collision. Our goal here at the CHP is to make sure that we're training more officers, both CHP and allied, in DRE as well as A-RIDE and SFST, and we have done so over the last 2 years. There are $2 million allocated annually for backfill overtime reimbursement, which is provided to area offices to offset the impact of operations while a student's attending a school or field cert. And lastly, there are 17 DRE classes scheduled to run throughout the state during the 23-24 grant cycle with an average maximum capacity of 35 students per class. Thank you.
Thank you very much. Ms. Ho, you're up.
Good afternoon, everyone. So my name is Jeannie Ho, and I'm the section chief overseeing the driving under the influence licensing units with the Department of Healthcare Services. I just wanted to provide a little background about what we do here at DHCS. So we are the sole licensing authority for DUI programs throughout the state of California. So this just means that we have the authority to issue, deny, suspend, or revoke DUI program licenses. We license first offender programs, which are our wet reckless 3-month and 9-month programs, as well as multiple offender programs, which are our 18 and 30-month programs. So at DHCS, we're responsible for ensuring that all DUI programs are in compliance with Health and Safety Code and Title IX California Code of Regulations by conducting biannual site visits and complaint investigations at all licensed DUI programs. Some things that we would monitor for, we would conduct a walkthrough of the facilities to ensure that there's no safety issues. We'll check to ensure that all counseling staff are properly credentialed. We'll verify that DUI programs provide the mandatory minimum number of hours of counseling services and that participants complete all required services prior to receiving a completion certificate. And we'll also ensure that, if participants are dismissed from the program, that they're dismissed for valid reasons. So reasons that are specified in our regulations. So for example, that would be failure to attend program services for 21 days or longer without an approved leave of absence, excessive absences, or being physically or verbally abusive to staff or other participants. As far as DUI program fees, all DUI programs are funded solely from participant fees. So this just means that DUI programs do not receive any type of public funding from the state, city, county, and they're also not reimbursable by insurance companies. So all fees that are assessed by DUI programs must be approved by us, and that includes any proposed program fee increases. So we will, accept any reason for why a program needs to either charge a fee or increase an existing fee. We'll ask them for the justification, documentation to substantiate that fee increase request, including like a breakdown of how they determine that the proposed or that the program fee is the appropriate fee to charge. I also wanted to note that DUI programs are not allowed to charge more than 10% profit. So we'll actually review their actual and proposed budgets to ensure that any approved fees or fee increases will not result in excess profit for the DUI programs. If we find that a DUI program is deficient in meeting any of the requirements that's specified in our Health and Safety Code or Title IX, we'll issue a notice of deficiency to that program. So the program then has 30 days to clear the deficiency by providing a corrective action plan. So long story short, if the program fails to submit a corrective action plan, or if we don't accept the submitted corrective action plan, then the program may be assessed civil penalties, which may result in the suspension or the revocation of the DUI program license. So that's my very abbreviated summary of DUI programs, and I'll be happy to answer any other questions that you may have regarding our programs.
Super. Under 5 minutes, gold star. Thank you very much. So I'm not sure if any of you were listening to our prior panels, but I'm curious to hear some of your reactions to our previous conversation. In particular, Sergeant Voida. So I'm aware from RIPA data that CHP has generally a better track record on racial disparities and pretext stops relative to other police agencies. However, there's genuine concern, and I think well-founded, that any substantive change to DUI laws, in particular, we're talking about lowering BAC to 0.05, would increase the number of arrests along racially disparate lines. And that would be primarily at the hands of police officers pulling people over. I was wondering if you have reaction to that, how we might guard against that, what CHP has done in the past to be better than other law enforcement agencies on these grounds. I think you know where I'm going. I was just wondering if you could react to all of that.
Thank you for that. My area of expertise is in training and in our curriculum. I would respectfully defer that to Chief Johnson. If she's able to comment on that, I would defer to her.
Before you do that, and I'm going to put you on, you're up, Chief Johnson or Assistant Chief Johnson. Is there anything in the training about racially disparate enforcement of DUI laws?
Not that I'm aware of off the top of my head. I could go back and look at that, but I don't believe there is. I'm thinking through SFST, ARED, and DRE curriculum, and not that I can recall.
All right. Assistant Chief Robinson. Keep on calling you Robinson. It's Robin Johnson. I'm reading too quickly. Thank you for joining us.
Thank you, and thank you for having us. So in regards to your question, thank you for recognizing the fact that the RIPA data does show that we have a lower number of disparaging stops, if you will. But to answer that question, and I would like to refer you guys to a KCRA 3 interview that was recently done and a ride along that was done with our local Valley Division Sacramento CHP office that showed how we train, and not just for DUI, how we train in general to make a stop, and how you, as an officer in the car with the California Highway Patrol, I'm not speaking for any other agency, is very difficult to identify the race of the person driving the car from our position and our advantage. Remember that for the most part, we are behind a vehicle, unless obviously we're shooting radar or doing something like that where we're facing the vehicle. So our training is to look for things that are unsafe, vehicle code violations, and we make the stop for that reason. And all of our cadets are trained that way, and our officers are trained that way, and it's not based off any type of racial motivation.
I know nobody's, or I'm going to assume good faith on people, that nobody's trying to stop people of color more often or arrest people of color more often, and that's not widespread. But I think that we all have to agree that it happens. And one of the concerns that this committee has had across not just DUIs, but every issue that we touch is making sure that we don't exacerbate the inequities in those inequities in the justice system. Because traffic stops are a very frequent place that people encounter police. We want to improve public safety at the same time, but decrease the racialized problems. So I was curious if your reaction is if BAC levels were reduced in California from 0.08 to 0.05, how CHP might account for those concerns, or would be CHP account for those concerns, or is it, you think, not really something that can be achieved?
I think that that would be something that we would probably discuss, administratively, and obviously talk to the experts and in the training. But I don't believe that that's going to change the way that we do anything currently. I feel like that we do things the way that we're trained. We had, and as a department, we're always open for suggestions and making adjustments as needed. But I don't believe that it would change. Lowering the BAC is not going to change the way that we conduct a DUI enforcement stop.
Do you expect that? Okay, although we learned that there was no training on the basis of race within the DUI training, I'm sure that there's within training for CHP generally. So I don't want to, and I'm very wary that you guys, and nobody probably wants the legislature meddling on what should be included in different training. But have you thought about, or is there any reaction from CHP about what the impact on lowering BAC from 0.08 to 0.05 would have on the agency, or on road safety, more importantly, I suppose?
Dustin, do you have anything that you would like to add from that perspective? I'll let him speak on that if he does, but I will tell you from a departmental perspective, we have not had that overall conversation. When Rick contacted us, that was the first kind of conversation we had, and Dustin, we were asked to speak on the training, and so we haven't gone into depth on looking into what the effects would have on the department at this time. But we definitely are now. It has opened our eyes, and we're interested to look further into it for sure.
Mr. Wojda, do you have a reaction?
Yes, I think there are some potential benefits, some potential challenges. I think the benefits have been outlined by past presenters, given the Utah statistics. The challenges that we could anticipate facing are having more to do with the process of effecting a DUI arrest. And what I mean by that is our preliminary alcohol screening test, or our PAS test, is our last test that we do. And so we are trained to determine impairment prior to getting that PAS reading. There's a couple of important notes on why that happens. One is if you're just relying on a device, then you're going to miss other impairing factors. So someone who might be under the influence of a combination of methamphetamine and heroin will still blow 0 on a PAS. So if you have that individual in a car, you pass them first, you have a higher likelihood of letting them continue down the road, although they have impairment issues. It's also important to remember that the PAS is not required. So we have research that tells us 4 out of 6 clues while conducting the horizontal gaze nystagmus test gives you a certain percentage of reliability that the subject is 0.08 or higher on BAC. Same with our walk and turn, same with our one-leg stand, which are our field sobriety tests. Now, using those as our reference, if they refuse to blow in a preliminary alcohol screening test, we can make a reasonable determination whether or not they are at or above that 0.08. The difficulty comes in not having the scientific validation for that 0.05 to 0.08 range. So how many clues would one expect to see on HGN at 0.05?
So I'm sorry, just make sure I understand. The pads could pick up the 0.05. But you're saying that the sobriety tests, walking a straight line, I don't even know what they are, but that those are not calibrated to 0.05, they're calibrated to 0.08. So you need to recalibrate those. Is that what you're saying?
It's not to say that they're not calibrated to that level. They can show impairment. Those are psychophysical tests designed to show impairment, but there's no study relating a percentage of probability of clues that you would see to a 0.05 to 0.08 range, while there is at a 0.08 and higher.
Got it. And I assume the field sobriety as opposed to the breathalyzer test, that picks up impairment related to all sorts of substances. It's not unique to alcohol. Is that right?
Correct. The field sobriety tests or psychophysical tests, they are designed for impairment, detection of impairment, while a breath machine, a breathalyzer, a PAS is designed merely to find out what the blood alcohol concentration is. It doesn't determine impairment.
And just to confirm, you can arrest somebody who is impaired even if they're blowing a 0.
You would have to justify the reasoning behind that. If you think they are impaired, usually that's where the drug recognition expert would be called to do an evaluation at the office and determine if it's drugs that are an impairing.
Well, at the office, or like what goes on the highway?
Say that again, I missed that.
So you said at the office. I was curious. So what happens? I get pulled over on the highway. They think I'm impaired, but I'm blowing a 0. I can be arrested.
If they believe you're under the influence of the drug, yes.
Yeah. Got it. Ms. Ho, I had 2 quick questions for you. It sounds like your office does not evaluate the efficacy of the programs that you mentioned.
Correct.
Is there any data that measures the efficacy of these programs?
That's not something that, is under our jurisdiction, so I wouldn't be able to answer that.
Is there anybody who has jurisdiction over the efficacy of the program?
Not within my units.
Within the state?
I'm not sure. I can get back to you on that.
Rick, do we know? Does anybody have oversight over?
DMV possibly, but I'm not for certain. They come out with an annual report to the legislature.
So there's a licensing requirement process that you administer, and you just describe some of the criteria that you make sure that are enforced. And that's how a school becomes licensed in order to offer the DUI class. But we're saying that efficacy is not part of that licensing. Is that what we understand?
Correct. We get the participants after they've gotten their DUIs and that they've gone through the sentencing process. And, so they're typically referred from both the court and the DMV to complete the DUI programs.
Right, but I was just talking about the licensing stuff before we get to that. Rick, Tom, how confident are we that is anybody evaluating the efficacy of these programs?
DMV did an evaluation, I believe, of the programs in the 90s, but that evaluation also coincided with the admin per se license suspension. And I believe the study found that the combination of requiring to do the programs plus a license suspension reduced recidivism. DMV can.
I'm not asking what the efficacy of the programs that are the classes that we're talking about.
Right. Specifically to the classes themselves, I'm not aware of any research showing that California's classes are effective.
And is there anybody, I'm not even asking for research on the classes, is there anybody it seems like Ms. Ho's office is responsible for the licensing of these classes.
Right.
According to the criteria that she discussed, but nobody is overseeing these programs in terms of efficacy.
As Ms. Ho mentioned, DMV does some basic evaluation. What they did was they looked at recidivism rates for people ordered to complete a 3-month class versus people ordered to complete a 9-month class, and they found that no differences. So essentially,
that's not quite what I'm asking. I'm just saying, if I'm a provider of classes, do I have to prove that my class is any good?
No.
All right, that was my question.
Right.
Okay. And Ms. Ho, you also mentioned that there was that you oversee or monitor fees related to classes. Does that also include the interlock fees and that might be associated with?
No, we don't oversee IIDs.
So it's just the classes. Is there any objection from you or any problems that you could see one of the concerns that was raised earlier was that these classes can be cost prohibitive to some people. Is there any concerns with you that the state or others make sure that those are covered so that everybody can participate in the programs?
Well, for our DUI programs, we do have provisions in place to accommodate the participants that are unable to pay DUI program fees. So typically, if they can provide documentation that their monthly income level is at or below the general assistance benefit level for the county that they're enrolling in, then they could qualify for, we call it a fee waiver, but it's essentially the option to pay $5 a month for all DUI program services. If they do not qualify for the $5 per month payment plan, then the program has the option of granting an extended payment plan option to the participant, which will allow them to make lower monthly payments for an extended period of time, or they have the option of selecting the reduced payment option, which is basically like a sliding scale to reduce the DUI program fee for the participants.
Is that something that you monitor
Yes.
or is it this, or is it, so the courts, who does the evaluation, says this person qualifies?
The DUI programs do the evaluations. So if a participant requests a financial assessment, then the program has 5 days to complete the financial assessment and request income documentation or whatever financial documentations the participants can provide to determine whether or not they qualify for any of the other payment options.
Got it.
And so I think this is something Mr. Green was mentioning too earlier. So we call it a waiver, but it's really a reduction. I mean, it's a pretty significant reduction, but it's not a waiver in the sense that, or in the ordinary usage of that word, I guess. And then there's also the option of just giving the person more time to pay the full cost. Is that right? And then who decides which one? Is it the person who says, I can't pay, I want to pay the $5 or I want more time to pay, or is that the program that decides that?
It's usually the program that decides it, but most of our programs are pretty lenient with that. So even participants that don't qualify for any of the payment options, I find that most of the time they'll say, you know what, we'll go ahead and allow you to either make like a lower down payment or we'll extend your payment options anyway, just to kind of help the participants out.
Is there a reason why we're not at zero? Why is this $5?
You know, I don't know. This regulation has been in place for over 20 years. So I don't know the exact reason why they determined that it would just be $5 instead of 0.
All right. Do you have any objection to go? Does it make sense to you to move it to 0?
I mean, that would be a policy decision, so I'm not able to answer that.
All right.
But Mike, it sounds like even if it could be 0, the plan decides whether they want to take 0 or charge more, but give the person more time to pay. So I think there might be a need to actually say 0 is 0, not let's string this out. It kind of reminds me of the restitution stuff we've looked at. And is there any data about how many waivers there are versus the extension plans? I think we talked about this a little bit before, or Rick has mentioned it.
So every quarter, we require DUI programs to submit a quarterly enrollment report to us that tells us how many DUI enrollments they received for that quarter. And part of the form requires them to tell us how many quote unquote fee waivers they approve for that quarter. So we do have documentation of the number of fee waivers, but we don't ask them how many extended payment plans or reduced payment options they offered.
Do you have a rough back of the envelope? And I see that your hand is raised, Ms. Johnson. Do you have a back of the envelope? What percentage of people receive a fee waiver?
For 2023, because fiscal year 2024 isn't over yet, I believe we've approved, I want to say 1,500 fee waivers for the state. Yes, so it was 1,511, as opposed to previous year, which was 1,210. So we saw an increase of 300.
But out of how 1,500 out of how many people take the program? I assume a lot.
Yeah, I don't know exactly how many people have enrolled in DUI programs.
What is it, Tom?
Well, there's about 100,000 arrests. So even if, 20% of those resulted in a conviction, I think it's much higher.
We're talking about less than 10, way less than 10% of people.
I think way less. Yeah.
Yeah.
And Ms. Ho, you mentioned that programs have the option to either provide the extended payment plan or to provide a reduced fee. And do you have any indication of how many programs are choosing to provide the reduced payment versus how many programs are choosing to provide the extended payment option?
Yeah, so even though DUI programs have the option of either of the two, all of them opted for the extended payment plan option.
Oh,
there we go.
So if they do the $5 waiver, do they get reimbursed by anybody?
No. No, so if the programs provide services for $5 per month, they pretty much absorb the cost of providing DUI programs.
And it's up to them to decide on whether or not to do this?
No, they all have to do it. Nobody can opt out of this option.
I think
that is something that we monitor for.
But it's up to them to whether to do. Sorry, Rick, you do it. We're going to ask the same question.
My understanding
Sorry,
is that the $5 option is for people who qualify for county general assistance. The programs have to give them the $5 option. For people who are low income but do not qualify for county general assistance, the programs have the option of either providing an extended payment period or a reduced fee that is somewhere above $5, but not specified in statute. Is that correct?
Well, that's kind of true. So if they have an award letter from the county or, anything saying that they qualify for general assistance, then that would be the easiest way to go. So all they have to do is show that document and the program.
And then you get the $5. We're talking about
the program has to give the $5 to the participant.
Right. We're talking what I think Rick is getting at is the people who don't qualify for the $5, but are still financially hard pressed to pay for the full fee. And then it seems like it's fully up to the school or program as to whether or not to defer payment over a longer period of time or say like, you know what, give us $10.
Yeah, so for the participants that still make at or below the county benefit level, but they do not have general assistance, they can still get the $5 per month without having an award letter, so long as they can show what their monthly income level is, that it's below that set amount, that general assistance amount. If there is a formula that the program uses to determine whether or not the participants qualify for a reduced fee or an extended payment plan. So it's not like you either qualify for the $5 a month or it's up to the program. There still is a formula that they have to use to determine what income level they have to be at in order to get either the reduced option or the extended payment plan options.
Right. Ms. Johnson. Thank you.
I just wanted to circle back on your question that you initially had asked Sergeant Boyda on the racial profiling type of training. Do we have any within our drug impairment training? And we as a department have racial profile training overall, not specific to DUI. We have, yeah. So when you said we don't want the legislators to dictate that training, I wanted to make sure it is in our curriculum for cadets and it's in our annual training for officers. So it's It's not something that we don't train on.
Every officer gets the training. Not every officer gets, does every officer get the DUI training? The basic DUI training?
Every officer gets the basic DUI training, and then there, as Dustin had mentioned, there's the drug recognition expert and some other advanced
the higher
training.
level, more
Correct.
expert level.
Correct.
Yeah. That makes sense. All right, I've exhausted my questions. Assembly Member Brian, do you have any additional questions? Judge Espinoza.
No, thank you.
Rick or Tom, is there anything that we should touch before we move on?
Very briefly, I was just going to ask Sergeant Warrior to talk about the lab testing that CHP conducts in relation to the 0.05 or 0.08 BAC, and kind of what CHP has observed about people's perceived level of impairment at different BAC levels.
Yes, thank you. So what we do within our standardized field sobriety test training is correlated alcohol study, commonly referred to as a wet lab. We also do 2 of these for every DRE school that is conducted. What this does is we dose individuals with alcohol, known quantities of alcohol at a certain percentage, and we dose them over a 3-hour period. And during that time, one of the questions that we ask these individuals is to let us know when you think you're impaired. Let us know when you think you're at the point where you could not safely operate a motor vehicle. And while this is certainly anecdotal evidence and something that we're looking into actually quantifying, the majority of people will raise their hand at around an 04, 05, and they say, hey, I am feeling impaired. This is the point that I feel like I'm no longer safe to drive. Another interesting fact that we see during these studies very often is something called the Mellanby effect. What that is as your blood alcohol concentration is rising, you're mentally taking note of that. You can feel the effects going from sober to less sober. However, it's the opposite as it's dropping. So when it's dropping, going from less sober to more sober, you're more likely to overestimate your sobriety. What I mean by that is we often see people at an 04, 05 say, I am no longer safe to drive. And then they get to the 08, 09 and they say, hey, I want to change my mind. I actually think I'm good to drive now. Or as they're coming down from, let's say, a higher blood alcohol concentration, we don't get them this high in our labs that we do, but if they were at a 0.16, for instance, as they're dropping to 0.10, they're going to feel very sober compared to what they were at the 1.6, and they're more likely to take that risk to drive because they're overestimating their sobriety. So just a couple of interesting things to note there.
Now, and this is the final question, CHP or any police officer, somebody was at 0.05, they blow 0.05, an officer could still arrest them if they observed impairment. Is that correct?
That's correct. But your
emphasis on could, it sounds like it's rare.
I would have to look at the exact numbers, but it's not common that someone with alcohol only in their system is arrested. Officers do tend to rely fairly heavily on that per se limit, but we do stress the importance of training and identifying an impaired driver under the 08.
Of course, because you don't know what's going on. Yeah. All right. Thank you all very much. Very much appreciate everything, your time, your submissions, your insights here. They're super helpful to us. So, thank you. We're going to take a lunch break now. Tom, you seemed that you wanted to intervene for a second.
It's a scheduling things. I think we could either try to get everything done before 2:30 or take a break from 2:30 to 3, and we'll have some folks have to drop off, but everyone will be back around 3, I think, for the most part. So we can do the next panel around 1:15 and then sort of see where we are, and if we need to break from 2:30 to 3. I just wanted to mention that because that might impact how long of a lunch break you want to do too.
All right. So let's do what you suggested, meaning let's do the see where we are. Let's reconvene at what time? 1:15? Is that what you suggested?
Yeah, which is about a 45-minute break, which is,
why don't we, can we do less? Can we do half an hour? Or does that not make sense?
I think our judges, our next panel is 3 judges, and we want to. I don't think we told them to come until 1:10. Rick, is that right?
Right.
All right,
So
so we can't rush them. All right.
right,
Everybody, you know.
we have to respect the judges' time. We respect everyone's time, but especially the judges. Mike, come on.
I'm trying to respect our judge, California's top judge.
Of course.
All right, so let's take a 45-minute lunch or 40-minute lunch and reconvene at 1:15. Then we'll see if we should take a break to accommodate Judge Espinoza's schedule. Rick, did you have something you want to add?
No.
All right, everybody enjoy their lunch. See you back in about 40 minutes.
Great.
When I asked them, would you vote in 2024 for Biden or Trump if it's not Kennedy? You get a pretty good split
Doing like he just said about that, you got people
All right, if people could start coming back to their Zooms. Good afternoon, everyone. We'll get started in a minute.
Thank you.
All the panelists are here, Mike. And hi, judges. Thank you for being here. We know it's busy. Really appreciate it.
Let's give Assembly Member Brian a minute. If he's not here, we'll get started in a second. Right. We're all here. Thank you, everyone. So we're back and we have one more panel. We'll do some quick administrative updates, hear from our legal director, Tom, discuss what our witnesses said this morning and at this last panel, and then conclude with public comment. For our final panel, we'll hear from judges throughout the state who preside over DUI collaborative courts. Thank you all for being with us. We have Judge Lawrence Brown from Sacramento, Judge Christine Eagle from San Joaquin, and Judge Scott Cooper from Orange County. I especially enjoy saying this to judges. We're prepared. We've read materials. I hope you've read ours. Please keep your opening comments to 5 minutes. Most helpful thing for the committee is the Q&A part of the conversation. Judge Brown, we'll begin with you.
Well, it all began when I was born in 1964. No, Mr. Chair and members, thank you for the opportunity to join you here today. Presently, I serve as the assistant presiding judge of the Sacramento Superior Court and as the supervising judge of our collaborative courts. For the past 4 years, I've presided over our DUI treatment court, which was established in 2017. Initially, the court focused on third and fourth offenders. As you know, fourth offenders are felony matters. In more recent years, based on the success of the court, it's been expanded to include fifth-time DUI offenders on a case-by-case basis. As a general rule, I'll note that DUI offenses involving injury are typically excluded. As a brief overview of our court, we have published guidelines for defense counsel when determining whether to pursue our DUI treatment court for a given client. An application is made, a designated career prosecutor reviews eligibility, and the treatment providers that we use and the designated probation officer, they review the matter for amenability to treatment. Assuming that all the boxes are checked, then the person appears in my court and they do a court observation. If they like what they see and they're willing to join the court, the next time they will then join the court. So with the sentence, whether it's a county jail term or an 1170H county jail prison term, as we call them, or a state prison term, that sentence is imposed and then suspended. And the defendant is placed on the probationary length that the statute provides for the particular, whatever DUI offense that might be. We impose and suspend all fines and fees in the matter. And if they graduate from the court, all the fines and fees will go away. They have a requirement to serve a short period of jail in the beginning as part of the probation. If it's a fifth-time felony, it's 90 days, which is actually 46 days with credit, of course. So, and then before they're released, they're in my courtroom in the holding cell. The treatment providers are in the courtroom. They're told which of the treatment providers they're going to now get services from. There's also the probation officer in the courtroom, and they're given release instructions of when to contact the treatment provider, when to contact the probation officer upon their release, and then they come on our next court hearing. We hold our court the second and fourth Fridays of the month. It takes at least a year of successful participation in our court before a person's eligible to graduate. Upon graduation, that suspended jail or prison term is lifted or permanently stayed. The case is not dismissed, however, and they do remain on probation. Once they complete their SB 38 program, they can return to court and seek an early termination of that probationary grant. During their time in the court, they must advance through 3 phases. When they phase up, they share an essay in open court. Kind of, how did I get here? What have I learned? What advice could I share with others in the court? They attend outpatient classes, twice monthly peer support group meetings among fellow participants in the court. Many are involved in NA or AA. They, of course, test regularly with their programs as well as with the probation department. If we start to see problems as to sobriety with their substance use disorder, we may refer them to an intensive outpatient program, perhaps a residential drug treatment program, or our final act of desperation, particularly looking at a prison term, I send them to our in-custody treatment program at our branch jail, which takes about 4 to 6 months to complete. At any given time, we have between 35 and 40 participants in the court. Last year, we had a graduation rate of about 73%. The year prior was 60%. As one might expect, and certainly as our community would demand, it's a strict program with a high level of supervision and accountability. At the end of the day, it is very treatment focused, with a shared goal among defense, prosecution, probation, treatment, and the court, that the participants find a sustained path to sobriety, thereby repairing lives, both their own and oftentimes loved ones, and protecting our public safety by drastically reducing the risk of reoffending. But one statistic, from December of 2018 to February 2023, of our 58 graduates, only but 5 were rearrested for DUI, which with my liberal arts math calculation gets me to just under 9% recidivism rate. Additionally, of course, and finally, there are significant incarceration savings. Last week, among our 4 graduates, there was a combined 7 years, 4 months of jail or prison time that had been suspended, that needn't have to been served because they graduated the court. Let me end my remarks by noting that we're very proud of our court in Sacramento. It's a jurisdiction that has long taken DUI offenses very seriously. And we believe that we strike a proper balance between treatment and accountability so as to promote public confidence and ensure their safety. Thank you.
Thank you very much, Judge Brown. Judge Eagle? Oh, you're on Zoom. You're on mute.
Thank you for inviting me today. I'm from San Joaquin County. I've been on the bench for about 9 years, and in the last 2 years, I've been the DUI treatment court judge, as well as a number of other treatment courts. Our treatment court does operate somewhat differently. All of our treatment courts here in San Joaquin County are grant funded entirely. So sometimes things fluctuate with the grants. With DUI court specifically, the way that it operates is that referrals are made usually at plea. All of the judges who handle DUIs and specifically repeat offender misdemeanor DUIs, they can be referred at plea by the judge, and all the judges know how to do that. They are screened by a validated tool, which is called the RANT. And if those offenders are high risk and high needs, meaning they're likely to reoffend and they do have treatment needs for addiction, they will be sentenced to their jail time, fines, and monitoring, treatment, and they also have a case manager. During the time that they are in DUI treatment court, they will be monitored by the case manager and also the court. For our program, there are rarely felonies since our felony DUIs go to probation and they have their own monitoring and treatment through probation when they're on formal probation. So almost all of our DUI treatment court clients are misdemeanor offenders. There are actually no exclusions that we operate on. If a judge has seen fit to put this person on probation, then they can participate. But it's not a choice. If they qualify for DUI treatment court and the judge has indicated it's going to be a condition of their probation, then they will participate in the treatment court. Like Judge Brown's court, it will go on for at least a year. After a year of monitoring and treatment, they can graduate. At graduation, their fines will be stayed and any remaining jail time will be stayed. The way that our program works, if the sentencing judge believes that the defendants need to do a period of time in jail, they will do that first, and then they will come to our court. At the end of the court, and also a little different in our model is that the only way that you will get deleted from our DUI treatment court is if you commit a new offense down the line and get sentenced to prison, then you get deleted from the court. Or a person can and occasionally does refuse the terms of probation and go to spend the balance of their year in jail. So those are the general guidelines that we operate on for our treatment court. I'm unable to give you good numbers right now of our recidivism rate, although I can tell you it's very low. In part because people sometimes spend a great deal of time, the majority of their probation, in treatment and in monitoring, but the numbers have been revised recently, and I don't have enough confidence in them at this point that I can give you a direct number. And that's basically how our court works.
Judge Eagle, before we proceed real quick, can you give us a sense of the scale? How many folks are involved in your court?
Yes, right now, active participants, we have 162, and there are some on warrant. There's about 60 people on warrant that are, we've lost track of them. They'll be back.
Got it.
Probably.
Got it. Thank you.
Thank
Judge
you.
Cooper.
Thank you. Thank you for inviting us all here today for this really important discussion. My name is Scott Cooper. I am the supervising judge of our collaborative courts here in Orange County. I've held that role for about 1.5 years, and I've presided over a DUI court here in Orange County for just under 4 years now. I'll try to be respectful of everybody's time and keep my comments to those that are different or unique from what the prior 2 judges have described. I think our program sounds like it's a little closer to what Judge Brown was talking about in Sacramento. But let me just tell you a little bit about ours. We actually have 4 different DUI court programs in Orange County, and those are at each of our 4 different courthouses that serve a different geographic area. So we try to keep our participants connected to the court that's closest to their location of residence. In the 4 programs total, we have about 190 participants right now. The model, of course, is to focus on treatment and supervision as opposed to incarceration, trying to eliminate that root cause of the criminal behavior. In this case, the substance use disorder that would lead to driving under the influence. We do it by collaborating with a team of stakeholders similar to what the prior panelists have described. We have our prosecution, our defense lawyers, the treatment providers, as well as the probation department, all are stakeholders and partners in these programs. We are fortunate to have those all funded by our county, who funds all those different agencies. And so we don't have to rely on grants. We actually get, the county provides the funding for all the stakeholders. Similar to Sacramento, we focus on those with multiple DUI offenses, starting with 2, going up to 4, and then we actually take more than 4, as Judge Brown described. In certain situations, we can take more than 4. We're looking for people who meet medical criteria for a substance use disorder. As Judge Eagle mentioned, we're looking for higher risk and higher needs people, those who have a substance use disorder, and we're not looking for those who either don't have that or can get better on their own. We're looking for people who need the intensive treatment and monitoring in order to get sober. The referral process is similar to what's been described in the other counties. They're referred to our programs from multiple sources, primarily defense counsel, They're then evaluated for both eligibility and suitability in a manner that sounds very similar to Sacramento, including the in-person assessments that are done to make sure they meet criteria. Once they're found suitable, they enter the program by pleading guilty to their charges and being placed on formal supervised probation, which includes the DUI court terms. They're also ordered to serve time in custody and to pay fines and fees, but that custody time and those fines and fees are stayed pending their successful completion. Once in the program, they're monitored and supervised and tested by an assigned probation officer. It's one-to-one. There's a probation officer assigned to each of our participants. The testing is urine testing that's done randomly and observed at least 3 to 4 times a week. They're also given an intensive treatment plan that's tailored to the needs of each participant, which can go all the way from detox and residential to outpatient treatment. They're brought back to court for regular progress review hearings at the beginning of the program. That's usually every 2 weeks. It can be extended somewhat as they progress through the program and get into later phases. At each of those progress review hearings, the participant will come in front of the court and in front of all their fellow participants and the team to discuss their progress to that point, see how they're doing. And as necessary, the court might provide incentives or sanctions or treatment adjustments, as may be necessary to promote their progress and success in the program. In terms of our length of program and phases, we're a little different for our misdemeanor participants. Our program is 12 months minimum with 3 different phases. Each phase has its own requirements. For felonies, our program is a minimum of 18 months and has 5 phases. As in the other programs, when the participant graduates, the stayed jail time and the fines and fees are vacated. The probation reverts to informal. Participants can come back at a later time and ask for dismissals under certain circumstances, but the dismissals typically are not given immediately upon graduation. If the participant is not able to finish the program and graduate successfully, and that's typically due to persistent or uncorrectable violations of the terms and conditions, the participant may be terminated and the stay jail time and fines and fees would then be imposed. Graduation is the rule, not the exception. Terminations are actually the exception. If you look at just termination versus graduation over the last 10 years, we have a graduation rate of approximately 88% versus 12% for terminations. If you look at graduations versus all the reasons to exit the program, it's in the high 70s, I believe, close to 80%. In terms of our recidivism rates, we've worked with the Department of Justice to look at the recidivism rates. If you look at any conviction for a new DUI-related offense within 3 years of graduation, so it's a conviction within 3 years of graduation for a DUI offense, going back all the way to 2017 to the present, our rate is approximately 5 to 6%. It's middle 5% for DUI-related offenses. And if you look at all offenses, it's roughly 9%. So I do think these programs provide both the societal benefits of the reduced recidivism rate, the safer society, as well as some of the cost savings that Judge Brown mentioned. But you also have the individual benefits of these people's lives literally being turned around, which not only affects them and their productive membership in our community going forward, but also can really affect generations, because we hear from a lot of our DUI court participants how they have been at a family that has generational alcohol abuse. And we feel like if we can put a stop to that with this participant, that perhaps we're affecting those future generations as well. So we are proud of these programs. We're appreciative of the ability. I frankly feel appreciative to be able to serve in them. And I appreciate your time letting us speak today. I welcome any questions. Thank you.
Thank you all. I really appreciate everybody's time. It's not the first time that we've talked about collaborative courts here. And in general, I should say that they're very enthusiastically presented, and there's a lot of great data to support them. For the committee, they hit what I consider kind of our sweet spot, which is where we're improving public safety and reducing incarceration and necessary punishment at the same time, right? I wanted to talk, my questions relate to 2 problems that I see relating to collaborative courts. Generally, DUI courts obviously are part of that, which is first, this is all just done out of the goodness of your hearts, right? There's no statute that says anything that county, that we should have a collaborative court system. This is just because your counties, whether it's run, initiated by the courts or the DAs or whomever, have decided to set up these programs. That's the way that I understand that all collaborative courts generally work. And that's why some counties have them and some counties don't. Also, it's why rules vary from county to county, right? Because it's just the county kind of slow walking a plea. Is that a fair way of assessing it? In any event, maybe that's a bridge too far. But so my first series of questions is there a role for the state legislature to provide statutory framework for these collaborative courts and DUI courts in particular? Before you say what we need is money, I get it. That's what everybody says that we need. Beyond that.
Oh, well, there goes my remarks.
Yeah, no, I know. And the second question is, how do we make these things scalable, right? It seems to me that collaborative courts are kind of boutique or bespoke, or they involve everybody in difficult problems. They get multiple agencies and looking at the same problem from different perspectives, and they really kind of, as much as possible, provide just more wraparound support services and attention. And how do we give that benefit to more people? Honestly, I mean, I think that you guys both all know that this is probably a small fraction of the DUI cases, or the people who could, let me put it this way, people who could benefit from this type of, but just for triage reasons, you need to limit it to. Those are kind of my questions. I guess let's start with the statutory one. Do you think it would be beneficial to the state to have some sort of statutory framework for these collaborative courts, putting the money question aside, in order to encourage all counties to have some sort of system like this and to create some consistency between the counties? If anybody, I'll let anybody jump in there.
I'll take an initial stab, and I chair the Judicial Council of California's Collaborative Justice Courts Advisory Committee. Though I'm kind of speaking somewhat in my own individual capacity, we certainly have these discussions in the committee. And, I think that the general view has been that one of the hallmarks of collaborative justice courts have been allowing things to kind of germinate within a community, reflect kind of the mores and values of that community. And a court that you might be able to establish in Alameda County might not be one you would necessarily get in Kern County or what have you. But in terms of any, for the DUI matters, it would seem that, if you built in statutorily that an off-ramp for a person facing a third-time DUI sentence could be, going to something like a treatment court or a collaborative justice court, that would start to kind of put into statute anticipation that that's supposed to be kind of an option for the way a case might get resolved. But then to build out the infrastructure, frankly, it's not nearly so much about the courts. I mean, we all are kind of sunk costs. We have courtrooms and judges and flags and robes. It's really going to be for the providers in terms of them getting plussed up. And then, frankly, I think to buy off your local prosecutor office and your local defense office to staff lawyers to those courts, because nothing motivates a county like having grant funds available to build something out that policymakers want to see built out.
Is right now your limiting constraint in terms of number of participants, the service providers?
One more time.
Are service providers the limit, your constraining factor? Could you serve more people if you had more service?
I think as we stand now, our model is kind of where we want it to be. I don't have any treatment people sitting here with you right now, so I don't want to sell them out if they say, no, we need more. I know when we did mental health and grew all the mental health courts, we very much needed more resources for all the mental health providers. What I really need here, residential drug treatment beds. It's a 90 to 120 day wait for a man to get into a residential drug bed. 2 to 3 weeks for women, 90 to 120 days.
Judge Cooper, Judge Eagle, do you want to take a stab at this statutory question?
I'll reiterate, I don't want to reiterate, but I second what Judge Brown said in terms of, I think having a statute out there that would at the very least encourage, if not mandate, some sort of program might not be a bad idea to get people moving in the right direction. But I do also agree that I'd be concerned about a one-size-fits-all kind of solution, because I do think every county is going to have different needs and different ways to address those needs. And so I think you'd have to leave some flexibility in terms of how the programs were designed. And then, of course, you get to the funding issue, which we've already talked about, which would be a big issue as well. In terms of the, oh, you just wanted the legislation. I'll hold off on the cap programs for a second.
And just so everybody knows, and I'll get to you in a second, Judge Eagle. You know, I understand the flexibility, and of course we want to have flexibility, but of course we understand that, you know, the interest of having equitable justice, and we have the same, you know, we shouldn't cross the county line and have a completely different system of justice. It makes sense to have, you know, consistency throughout the state. So I get that, but those are two ideas are intention and, you know, it's part of our government. You guys all know that. But anyway, Judge Eagle, you were about to say? I
was just going to say, I agree with everything both of my colleagues have said, emphasizing for a moment the point of flexibility with regard to different communities. The model that we follow is kind of notable, I think, throughout the state for not having any exclusions. In other words, taking the people that maybe are the least amenable to it, but because it is a condition of their probation, we have that period of time where we can continually, you know, hopefully it's not all coercion, hopefully it's some incentivizing, but throughout that person's period of probation, they are expected to be in treatment if they are assessing for treatment. So for our community, that is a successful model. And not to denigrate in any way the other very successful models that are represented here today, but that was the path that we took. And again, I'm unable to say numbers because of the revamping of our system, our statistical system, but they are also very high. I mean, they are probably in the 80s, high 80s. So,
right, given I'm going to press back on this idea of legislation before we get to scalability. They're tremendously successful. That's why we should expand them. So as you know, as people who try to make recommendations to the legislature, and the money, I get it. Like, but how could you imagine a statute that said, you know, people who fit these criteria, it's your third conviction, or you know, you have to go to a collaborative court, whatever the hell that means, because that's not defined by statute, and says that if you participate in a program that's been certified by the court, then all charges or penalties or whatever are reduced or dismissed. Is that the kind of statute that you all would envision if one were to exist?
In other words, loosely structured in terms of criteria, exclusion.
Yeah, I would say some group of some subset of people, whether it's third-time offenders, fifth-time offenders, multiple.
Right. Yes.
But you know, it has to constrain everybody, and so a program that would be approved are the programs. I presume that the programs that you guys all use are approved by the court. Are you guys, or the people who certify, say this one is a qualified program, or is it the DA's office, or who does that? That seems like a critical piece.
For us, they're just local programs that we have that have indicated a willingness to work with us, that we fund through our county behavioral health monies, or sometimes the grant funds. And yeah, we are a little bit at the mercy of programs available, but we've made it work.
So anybody who comes in and says, I provide drug treatment program, on good, then they get the rubber stamp, or do they have to be, all right.
They have to perform or we stop using them.
Judge Brown, I see you nodding. How do you do it?
I don't, that's kind of the behind the scenes. I do know that these are well-established providers that provide services to my DUI court. And it's not just limited to the DUI court. And they are, I think, vetted by, just like Judge Eagle was saying, by our county Department of Behavioral Health Services. The funding goes through that entity. Certainly, if we had any concern about, kind of the integrity of the program or the responsivity, then that's when we would kind of weigh in just to say, gee, do we have full faith and confidence in a program? But I know I'm not on the rubber stamp approving end of it. That's done by people with expertise.
In Orange County, the Orange County Healthcare Agency is the actual partner in our program. They provide clinicians in our courtrooms to be the liaisons for treatment and the court, but they also provide a lot of the actual treatment. So a lot of the actual treatment happens within our county healthcare agency. However, they do also contract with outside companies who might provide, for instance, residential treatment or detox or things like that, sober living facilities. Those are all contracted, and that similar to Judge Brown, I don't get involved with that, but I know there are contracts and there are requirements they need them to meet.
So I guess what I'm trying to get at is, imagine yourself being a legislator who's trying to draft a statute here that says, okay, well, we're going to make a subset of qualified people, third-time offenders, fourth-time, whatever the number is, however you want to decide, but they have to complete some kind of program. And there has to be some official entity that says this is a qualified program, especially if you want to keep the flexibility that you all say is critical to your specific counties, right? Do you think that authority saying you have been certified as a collaborative court treatment program should rest with the courts or Department of Healthcare Services, the Board of Supervisors? Who should say, and then if it was some other entity, then you, the judge, would be kind of saddled with, all right, the statute says if they complete this year-long program or whatever it happens to be, it gets dismissed. Or is this something that you think the courts should retain control over? Or is this something that's well outside you get where I'm struggling?
In terms of vetting the actual treatment providers, I think that would be difficult for the court to do. I just don't think we have the expertise to be able to do that sort of vetting. There would need to be somebody in the healthcare, behavioral health field who would be more qualified to do that. We at least in Orange County, we try to stay out of the treatment lane just because we understand we're not the experts, and we defer quite a bit to our treatment providers.
And as long as they're approved by the Department of Healthcare Services in your county, that's good enough for you.
The Orange County Healthcare Agency. And the Orange County Healthcare Agency there is a representative from them in each courtroom monitoring and approving all the treatment that's provided.
I get it, but you have to try to create just some generic statute that would work for everybody.
I think it's almost, I think it's just come up in different contexts in the past. I remember there's even some ethical concerns for judges in our canon of ethics to look like we'd be choosing one vendor over another vendor, what have you. So, and for many reasons, it properly rests not with the court.
All right. I'm monopolizing the conversation here, but my last question is about getting back to the scalability question. And I think, we've heard this again, not just for DUI courts, but elsewhere, that it's a funding issue, particularly as Judge Brown, you indicated, for the service providers to make sure that there's sufficient programs out there to send people to. Is that this, if money was not an option, I presume that you would expand this to include more people to get the benefit of the intensive supervision? And is the real logjam in getting money to the providers?
In my county, I don't believe that's probably the case. I suspect that.
Which you would not expand?
No, I'm saying is I don't think that's the log jam. I think it's kind of where it's been for whatever set of reasons. I'm told when the court was first created, we had an 18-month program like Orange County. It was even less attractive for defense counsel to have their clients considered. So we dropped it back to a year to get our numbers up. So we're, usually 35, 40 folks. And that's not because we capped it. Having said that, though, the one variable might be we have one probation officer, and sometimes that creates the limitation because they're going to have a certain caseload. So it probably has some tie into resources more related to the probation department than it does to the treatment community.
The reason why I raise this is, I'm not sure if you read our memo. This is maybe the most common criminal offense committed in California, right? There are 100,000 people who are arrested for DUIs every year. It's huge. So in order to make something be available to more people, how do we do that? So Judge Cooper or Judge Eagle, do you want to jump in on, is it the service or is it some other logjam that we should think about?
I'll just follow up on Judge Brown's point, because it's really the same situation in Orange County. That the only real limitation we have right now would be with the probation, because they can only handle a certain number of participants to be able to effectively monitor and supervise those people. But our probation department has been very, helpful in providing additional officers when necessary. So we are fortunate right now, and I'm going to knock on the closest piece of wood I can find and say, right now we haven't had to cap any of our programs, and we've tried to make actually a point that we're not going to do that, and we'll find ways to scale up and get additional resources when needed. But I think the biggest issue would be the probation officers, and then secondarily, as was mentioned earlier, residential treatment beds, like in Sacramento, are also lacking here in Orange County.
Got it. Judge Eagle?
All of that. And I would also say, at least for my county, there is no dedicated funding that our court gives us. So, which is why we're all grant funded. I mean, that was kind of the historical model for us. And the permission was given because we could do it on grant funding, and that was the model that propagated. So there would be even another stumbling block for us, in that the court would have to take away from resources that it currently has in order to establish funding. Probation has been historically very cooperative, but now they don't really, for a number of reasons that I don't have anything to do with us. They're no longer seeing themselves as a partner in this court. So all of these people are on informal probation, and the court and the case managers manage them and test them.
And when you say the grant funded, who's giving the grants?
So we have the one position that our court allocates for collaborative courts is the executive director of our collaborative court office. And that person manages grants, applies for grants, with some staff help. And that's how we fund our entire court.
I guess, but who pays for it? Who's the grantors?
Who gives us grants?
Yeah.
State of California, Department of Justice, the Federal Department of Justice, and Bureau of sorry.
But it's various government fundings. It's not really philanthropy.
Yes.
All right, got it. I've been monopolizing the conversation. Assemblymember Bryan or Judge Espinosa, do you have any thoughts or questions? All right. I'm going to wrap things up here. I'm a huge fan of collaborative courts, but I hope that you get the sort of issues that we're grappling with in order to try to develop policy. I think somebody who can sort of crack this nut is going to make a huge impact in terms of criminal justice and way it's administered in California, not just for DUI, but all collaborative courts, restorative justice. We've run into this issue over and over and over again, that there are better ways to improve public safety than just throwing handcuffs on and throwing people away. And we've been doing this for some time. It's just a matter of figuring out how to spread them out through a state that's as big and diverse as California. So
Mr. Romano, can I make just one other point about the statutory issue? One thing I just thought of, because I also preside over a veterans treatment court, and Penal Code Section 1170.9 is the Penal Code section that essentially authorizes a veterans treatment court program. It doesn't mandate it. It basically says you have to look at certain factors in deciding whether to give somebody probation. But then if you meet those factors, they can be put into this program. And it goes into some fairly specific detail on the program. So anyway, and I literally just thought of this, so I haven't really looked back at 1170.9 in detail for purposes of this discussion, but it may be somewhere to look as a starting point for a statute that does seem to at least allow and provide some parameters for a collaborative treatment program.
we've heard this before, that judges, even if it's not required, that it's a statute that permits, that kind of greases the skids, as it were, a little bit for courts to go down that road. Do you all seem to agree with that?
Yes.
Yes, and it also then gives that hook for seeking grant funding. I mean, we're all at some level in the hunt for, I know I just signed some letter for a SAMHSA federal grant to help provide some extra services to the DUI treatment court, for example. So when things are in statute, certainly we can key off of it and say, gee, we want to further this objective or what have you.
That makes sense. I hadn't thought of it. Well, as I say to everybody, no good deed goes unpunished. Thank you very much for your time and your insight here. We will reach out. Vice versa, if other ideas come to you, like 1170.1, 1170.9. 1170.91 is a resentencing for veterans that I know. Any event.
Mr. Ono, could I just, I need to get a restraining order against Mr. O, and I try to avoid this committee, but we're in the same inn of court here in Sacramento. In the food line, he shamelessly cornered me. So I wanted just to put that out there.
I will make sure that he keeps in line. I appreciate it looks like you were appearing in your courtroom, which I appreciate the official nature of it, and Judges Eagle and Cooper see we're in your chamber, so thank you for that too. Thank you all for your time. I really appreciate it. We'll be in touch, but vice versa, please be in touch with us if anything comes to mind, if we can be an assistance.
Thank you.
Thank you.
Have a good afternoon. All right. Thank you all. Again, it's been another long but productive day. We're, rounding the home stretch. We've heard from our witnesses, and we'll consider a few other matters before moving on to discussion. So we'll have, in other words, we're going to do some administrative things right now. That should be quick. And then we'll discuss what we heard today in terms of giving advice to staff for further investigation and research. So we're going to begin with the minutes from the November 2023 meeting. I move to approve the minutes. Will somebody second that, please?
Second.
Anybody opposed? All right, the minutes are approved for the 2023 meeting. Next, Tom will provide a brief legislative update and give us some data on violent crime in 2023. Tom?
Yes, let's start with the violent crime data. So we have, just to refresh everyone's recollection, this data comes from the Major Cities Police Chiefs Association. So it's a nationwide group that gets data from big cities across the US. And there are roughly 8 California cities that are in it. So it doesn't cover the whole state. It just covers the big cities, which tend to have, more violent crime than some rural areas. So
just also to refresh, we use this data because the state DOJ data doesn't come out till much later. So this is newer. However, Tom, correct me if I'm wrong, this sort of what we'll call preliminary data from the Police Chiefs Association is a pretty good indicator of what we think will come from the state DOJ later in the year. Is that correct?
Yes, it has been historically, and that's something I make sure to take a look at when the 2023 numbers come out, usually around July this summer. And it only covers violent crime, so it doesn't have property crime or retail theft, for better or for worse. And what we see is basically violent crime in the California cities was flat. It was down, but it was down less than 1%. And you see the 4 categories. Homicide is down 10%, which is great. Rape down 11%, robbery up 6%, and then aggravated assault down 1%. And robbery and aggravated assault, volume-wise, make up most of the violent crime reports. If we compare California to non-California cities, we see violent crime drop more outside of California by around 3%. Homicide drop was similar, rape drop was less, robbery declined, whereas it went up in the cities we looked at here, and aggravated assault went down a little bit more. And then because, LA County is so big, we can look at just the city of Los Angeles, the cities patrolled by the sheriff, and Long Beach, which is about something like 6 million people all total, so a good chunk of the population. And we can see pretty similar to the statewide trends, a little bit bigger drop and a 0.85% drop in violent crime overall. We did a staff memo about this too that has the data on individual cities, and the big, and it wasn't that violent crime went down the same amount or went up everywhere across the state. There's, it was down mostly everywhere except there was the biggest increase was in Oakland, which has obviously been a subject of special attention from the governor's office and other places. And if you were to take Oakland out of this data, we would actually see, a much around a 2% drop in violent crime. So just one city is skewing our results a lot, which, what we need to include it, but I think it's worth pointing out sort of the outlier nature there. And the other thing I'll mention on this is the FBI, who collects the nationwide statistics. They're starting to put out quarterly data. So I'm going to try to incorporate that into these presentations, but it's a lot more cities. So I want to just, do a little more digging around to see sort of how it compares to previous year's reports. But that will include property crime as well. So that's something to hopefully look forward to. So that's the violent crime update. Legislative update, we've got, what do we have? 7 bills here, and these are the ones that have been recently introduced. I won't go through them all individually. It's mostly stuff from last year's report, but a few things from years prior. And, Assemblymember Bryan is author of AB 2215, which has to do with the pre-booking authority for police officers to do pre-booking diversion. So that's a great bill. I'm very glad to see that one moving forward. All of these, nothing is scheduled for its first hearing. Yeah. Oh, I hadn't seen that yet.
Yeah, no fiscal, so it'll go straight to the floor pretty quick.
Well, let's not jinx it, but yeah, that sounds good. So we'll keep you all updated as these move forward. But yeah, things are just it's going to be a busy April. Let's put it that way, and hopefully a quick one. So that's it. So that's sort of the updates on those things, and we can talk about the rest of the hearing now if you want, Mike.
Yeah, just a couple of notes on what Tom said. First of all, the violent crime data. I mean, this is something that we continue to work on. We get queries from the governor's office, legislators, a lot about what's going on with crime rates in California. It's really staggering to me that there's not a reliable resource for that outside the Department of Justice, which provides it so late in the year. So it's something that we're continuing to work on, trying to be a better resource for that. With regard to the legislative stuff, that goes on outside of these meetings. Staff spends a tremendous amount of time on it. We're also assisted by Natasha Minsker, who's consultant for the committee, and relies on some outside funding. So that's a lot of work, and I just want to send an appreciation to everybody who's doing that. And it's why we do this. At least half of our recommendations have become bills and statutes, I think. Is that right? About right, Tom? About half of our...
Something like that. Sort of depends how you slice and dice it, but that's fair to say.
So, we're, if what we were doing, we're not just putting reports up on a shelf, in other words, and that's not just to the good work that we do in these meetings, come up with, I think, good recommendations, but also staff work behind the scenes. So I just want to acknowledge that. All right, finally, I apologize for the background noise, but so the question here is, Judge Espinoza, we have you for another 25 minutes or so, is that right?
25 minutes, yeah.
All right, let's at least begin our conversation about where we want to direct staff attention to based on our conversation from today. I will touch bases with Priscilla and Senator Skinner to also get her opinions, their advice on this too. I want to emphasize that we're not voting or endorsing any recommendation today, but only identifying areas of the committee as interested based on what we said today and what was contained in the memos. The goal is that staff will focus our attention on specific proposals and details and report back to us throughout the year. We will vote on recommendations at the end of the year. So we're not voting on anything. We are just trying to further refine our ideas. And of course, our recommendations won't come out until December of this year. So I want to quickly remind you of the recommendations in the staff memo. They're first, changing the BAC limit from 0.08 to 0.05. Number 2, increasing collaborative courts. 3, streamlining suspension, and any other ideas that we wanted. I should say that the first one, reducing the BAC limit from 0.05 to 0.08, has been paired with the idea of increased diversion with particular concern about offsetting racially disparate impacts. There was obviously a lot of concern and conversation this morning about the racially disparate impact of reducing the BAC limits and the benefit of reducing. It seems from the studies that I concede have not read, but have been summarized, that there is a genuine impact on reducing BAC limits. The question is that a benefit, in my mind, worth the potential cost of exacerbating over incarceration, over policing of folks of color? So focusing on that for a second, are there areas that Assemblymember Bryan or Judge Espinoza you'd like to direct Rick and Tom to look into?
I'm not sure I'm responsive to your question, but I would say, given the indicated benefits of reducing the BAC, to me, to be comfortable not endorsing a net widening legislation, it would have to be paired with some sort of, if not mandatory, shall divert. And we could even break it down. But if somebody gets picked up with a BA between 0.5 and 0.8, they need to be diverted. They do not need to suffer a criminal conviction as long as they're willing to do the classes that they would normally do with a conviction. I think if we leave it discretionary, it provides for widely disparate outcomes in the 58 counties. Now, whether that would ever survive the legislative process, I don't know, but it would make me feel a lot more comfortable. And I recognize this is a public safety measure, and I think it could be a great one. But if it is, I think Assemblyman Bryant used the word net widening. I'm concerned about that. But if we and these tend to be the people I think that have less chronic alcohol or substance abuse problems, and can benefit from that light touch that is the first offender alcohol treatment program, but it needs to be with a diversion at the end, a dismissal. That's my feeling.
Assemblymember Bryan.
I mean, I share the similar feeling as Judge Espinoza. I mean, in California, we have the power and potential to lead on many, many issues and many, many different times. We also run the scary responsibility of needing to get things right faster than others because our example weighs so heavily across the country. And so I'm not sure that I'm convinced. I need to read the international studies, but in terms of a state by state comparison, I'm not convinced that Utah's decrease and the explanatory power of the law change isn't overshadowed by a compilation of other unique characteristics to Utah. It's not a peer to California, right? Not, and I don't just mean controlling for population size. I mean controlling for a whole host of other things. And so the generalizability of those results, I think, gives me some deep concern. And the other thing with diversion is just ensuring that we don't. This reminds me of like the pretrial ankle monitor conversations, right? That we are not building up a massive interlock operation that is to some degree subsidized by poor folks who are now being required to pay for their own, least restrictive conditions of